Father, I come before you, Lord. I adore you. I respect you, King of Kings, Lord of Lords. Thank you, God, for giving yet another opportunity to be able, God, to do this recording. I don't take it for granted that the device to work, the Zoom, the internet, the laptop, and everything. Give me all knowledge and wisdom to be able, God, to dispense knowledge and the students, candidates who are going to watch this video to be helpful to it as they prepare for the exams. Give me views and subscriptions. I pray all this believing in Jesus Christ, my Lord and Savior. Amen. So, this is April 2024 Professional Ethics past paper. This is a recording ahead of April 2025 exams, which is going to be done in a few days. I'm doing the recording on 7th April 2025. And the exams is on Friday, professional ethics exams, 11th April 2025. So welcome to this recording, and I'm also going to do the last paper, which is November 2024. Yeah, so all the past papers are there. If you want to pass professional ethics, I keep saying that it is a very theoretical subject. You need to read a lot of statutes, regulations, notes, international legal instruments like UN Basic Principles for Lawyers, Bagalo Principles on judiciary, the Bagalo Principles. Yeah, so this subject is usually, there are 4 areas which you are usually tested. Number 1 is questions, and I'm talking about questions from 2008. From my research and in my interaction with the past papers, I usually say 4 out of 6 questions in every exams are from past papers, directly or indirectly. You need to interact with the past papers, which are from 2008, which are on my website. The first area is usually the journey of an advocate to go into Kenya School of Law, which is legal education. That is like 5%. Number 2 is the main thing, the advocate, practice and ethical issues. That is like 70%, where you read the Advocates Act as the bare minimum, regulations, advocate regulation, and SOPEC, Standard of Professional Ethics Conduct 2017. Then there is 20% of where an advocate now becomes join other professions like a judge, DPP office, county attorney, and other things. So you need to read statutes concerning those offices, regulations, code of conduct. Then there is the last percentage like 5%, which I called the miscellaneous question. This is a question that they are not necessarily professional ethics question. And practice, they want you to use your knowledge, whether knowledge gathered in other subjects, ATB subject, or the general knowledge that you know. And when we reach such a question, I usually say, yeah. So welcome. In the website, by exam preparation website, there is year 2008 to 2019. That is 500 June 2021, 100. I have done videos from all those papers from part 1 and part 2 for November 2021, April 2022, October 2022, March 2023, November 2023. Now I'm at April 2024 and I'm going to do one video. I'm not going to do part 1 and part 2. Then I do November 2024. Yeah, so welcome. I also watch videos, subscribe to the papers, read sequentially, invest a lot of time reading all the things that I've said in the past videos and the Q&A. You'll be in a position to be able to pass. Each and every paper is unique in its own sense, and but I usually say comments. Yeah, I also do physical class, subject to someone's affordability and my availability in any subject. So you can always contact me. So let's go to the business of the day. April 2024 is projecting on your screen, and I'm going to read. Fidelis Wamato, the proprietor of Farm of XYZ and Partners Advocates, is engaged as the advocate for administrator of estate of Walezo Kenza disease, namely Elizabeth Wenza Kenza and Moturi Kenza, in a succession dispute, in a succession cause. The matter has been subject to a protracted and lengthy legal dispute due to objection of some of the beneficiaries and third parties who claims on the estate. In course of representing the administrator of the estate, Amato advises them that one of the objectors to the proposed mode of distribution on an allegation of purchase interest, namely Africa Chan Foundation, should not be served summons for confirmation of grant. Underlying that one, that is a ethical practice issue. Engage in education of offer and specific performance orders related to completion of transfer of plot in Machakos to its ownership, having made requested permits of purchase price to the disease before demise. The objective of failure to serve someone is that the FC fails to substantiate the grounds of objection during the confirmation hearing. Further, one of the beneficiaries in the case alleges in an objection that the administrator failed to record one of the derived primary properties incurred in the schedule of asset of the asset field in court. The administrator proposed that they oppose the averments by reader by alleging the non-existence of such property, and they in particular intend to notify the title documents in court that they may continue to receive some of the rental income from the subject property even after the distribution of the estate. A proposal that Wamato endorses, underline that. Wamato processes the designated beneficiary purport situated to Muthaiga, Nairobi County, be Muturi, which suggestion the administrator obliged to. Wamato is motivated by the fact that can easily compel Muturi to sell the prime property to him at below market prevailing price upon eventual confirmation of grant. Underline that one also. Wamato's motivation. The administrators were previously represented by the firm of June, Keso, and Associate Advocates. Wamato proceeded to take over the representation of administrators and file a notice of change without informing the firm of June, Keso, and Associates. Underline that. And he did inform the administrator that such information was not necessary. Underline that. Consequently, the firm of June Keso and Associate declined to hand over the documents alleging the right of lien of unpaid fees. Wamato further advised the clients not to make any legal fees and disbursement payment to the firm of June Keso, as they have not filed the petition of grant and letters of administration and threatened only a few and attended only a few court mentions related to objection, but have not filed summons of confirmation of grant attended by substantive hearing. Underline that. Consequently, the client adhered to the advice which necessitated the firm of June Keso to file a grant bill of cost for taxation in court. The firm of Wakili Merevu Law LLP acted for some of the objections beneficiary to Wamato requesting that they seek reference on the matter to court-appointed mediator, citing the protracted nature of the matter, which has rendered it expressive and inconvenience to the client. They were they were of the view that largely a family dispute mediation offered an elusive solution to disagreement. Wamato responded by declaring the offer and categorically stated that he could oppose to any mediation offered as the matter should strictly be decided accordance with the law. Privately, he informed his client that he should put every effort to prolong the succession dispute, and then the objection beneficiary got worn out financially and emotionally to advantage of the administrator's board of sharing the estate asset. Underline that. He was also designated that the protracted legal battle meant more legal fees. Underline that. Kutokalisi, a tenant in one of the property that comprised the estate, had instructed by administrator to be making monthly rental payments to XYZ and partners client bank account. The rent payments had accumulated to 1.25. Upon pleading with the administrator, Wamato was granted an order facilitated by the bank to transfer 1.5 million from the firm's client account to the administrator for the emergency use of estate matter, which balance would be they paid from the rent payments within a period of 4 months. Underline that. Question number A. Evaluate the 5 breaches of the advocate's duties and acts or omission of professional misconduct by Advocate Wamato. So the question is telling you 5 breaches of duties of an advocate and all professional misconduct of the Advocate Wamato. So this is question of 15 marks. You give 5 points as asked. So each and every point give 3 points to get 3 marks. 3 marks times 5 breaches, you get 14 marks, 15 marks. So this question is not tested this way. From 2008, this is a question which I call mix. That is repeated indirectly. So I usually categorize question three ways: repeated directly from the past papers, and I usually say which question repeated indirectly. That means you use the knowledge from the past papers, the answers to do this, or never repeated again, never repeated before since 2008. So point number 1, failure to serve summons of confirmation of grant. So we are being told that Wamato advised the administrators not to serve summons on African Child Foundation with the intention of preventing AFC from substantiating their objection. This raises concern regarding improper conduct, as his advice is going to make it difficult for a party with a legitimate claim to be heard. Point number 1 under that. Professional misconduct is an advocate has a duty to act in the best interest of the country while also upholding the integrity of the legal process. Wamato's actions appear to be deliberate attempt to manipulate the legal proceedings to ensure that AFC, African Child Foundation, cannot challenge the estate distribution. This comprises the fairness of the court process and violates the duty to act within Remember, advocates are officers of court. Their first duty is to the court before to the client. Section 55 of the Advocates Act. Then you discuss Rule 21.2 of SOPEC, an overriding principles, the overriding principles of professional practice and ethical conduct is honesty and integrity. State that honesty and integrity are the hallmark of legal profession and must be exhibited by the legal profession in all his dealings with client, officer, fellow professionals, service providers, regulator, and other public authorities, member of the judiciary. Honest and integrity among members of the profession fosters trust and confidence in the professions and enhance moral standing and public image of the profession. Honest integrity and capacity, severity, professional integrity, uh, high personal moral standards, and respect for others, among other things. So those are 3 points. And as failure to serve, you get 3 marks. Another breach is concealing property from estate schedule. The breach is Wamatu endorses the administrator decision to oppose the claim made by Leader Kenza regarding the omission of prime property in Karen from the estate schedule, advising the property does not exist and directing that the title document should not be filed. Remember, this is one of the things that I was saying you underline. That is a breach. Point number 1 under that. Professional misconduct. This is constitute fraudulent behavior. Advocates are bound by the duty to assist the court in achieving justice by providing truthful information, encouraging clients to avoid omit variable property in the estate for personal gain. This is breach of Rule 125 SOPEC, which says that an advocate should not resort to illegal and unlawful means or sharp practice to advance his client cause. Examples of conduct which amount to professional misconduct in context of court include suppressing relevant information that could assist the court assisting in fraud. 3 points under that, you get 3 marks. The third breach is conflict of interest in Muthaiga property or self-dealing. Breach, Wamatu suggests to Muturi to be designated beneficiary of the private property in Muthaiga with the ulterior motive of acquiring the property at below market value once the grant is confirmed. That is point number 1 under that. Professional misconduct. Wamatu's actions involve a clear conflict of interest. As an advocate, has a duty to avoid situation where his personal interests conflict with those of the client. The advocate's duty is to act in the best interest of the client, not for personal gain. This is a violation of the ethical duty of avoiding conflict of interest. Then Section 46A, Advocates Act prohibits any purchase by an advocate of interest of any part of interest of his client in any suit or other contentious proceedings. You give 3 points, get 3 marks. The fourth breach is failure to inform previous advocates into bracket in paper handling of client's document. The breach, Wamatu files a notice of change of advocate without informing the previous firm of June and Kessel Associate, therefore disregarding the right to be informed about the change of representation. He further discouraged the administrators from paying the previous firm their legal fees. Professional misconduct. This is conduct violation of professional obligation to handle clients' matter with transparency and respect for the rights of other professions. Advocates have a duty to inform the previous firm when changing representation and act within the professionalism in handling client documents and deny payments for services rendered by previous firm also appears to be in bad faith. The notice of change of advocate violated Order 9, Rule 5 and 6 of Civil Procedure Rules 2010. What does it? They say Order 9, Rule 5. A party suing or defending an advocate shall be that party to change an advocate without order or purpose, but unless and until notice of change of advocates is filed in court, in which such case or matter is proceeded, served in accordance with Rule 6. The former advocates are subject to 1230, considered to be the advocate of the party until the final conclusion or course of the matter. Service of notice of change under 9 Rule 6. The party giving notice shall serve to every other party to the course of matter and to the former advocate. So it violated that. You give 3 points, you get 3 bucks. Breach is mishandling of client's account. The part was and partner's client account to administrator for magistrate use of estate matter, which is settled to be paid with future rent income. Professional misconduct. Advocates have a fiduciary duty to hand clients' funds with the utmost care and ensure that any disbursement from the client account is made strictly to the purpose which the funds are deposited. You see the client's account to facilitate an overdraft facility without explicit consent from the clients or clear documentation is a breach of fiduciary duties and financial misconduct. It violates the rules governing proper use of clients' money. Discuss Rule 21.7 SOPEC on overriding principles and values of professional practice is especially fiduciary duty to client. In its on her dealing of clients' funds and other property, the legal profession stands in a position of trust. Therefore, the legal profession has a duty to safeguard clients' funds and other property, fully account for them, not use them in a manner that to adverse to client interest. You give 3 points, get 3 marks. So that is question 1, which was mainly the question. So B, 1B, African Child Foundation is represented by the firm of Lasire Matano Advocates. The firm must agree not to charge any legal fees for representation. B1, explain the circumstance which is expectable for an advocate not to charge legal fees. So those are 3 marks. You give 3 points. So point number 1. So this is question is not the B is not tested directly this way since 2008, but this is a Q&A. If you have interacted with the research and the videos, you would answer this question easily. So I call it a mix question, which is tested indirectly. So what are the answers? You give 3 points, 3 marks. So pro bono representation, that is point number 1. Circumstance in which is expectable not to charge legal fees when you are doing pro bono representation. An advocate may choose to represent a client without charging legal fees as part of their commitment to providing legal services for the public good or individuals who can't afford to pay. This is often seen in cases involving charitable organization, indigenous clients, or point number 2, legal aid. Under the Legal Aid Act, advocates may offer their services without charging fees. Under the legal aid programs where government provides financial assistance to individuals in need of legal representation, typical in criminal cases or matter of social justice. Point number 3, charitable endeavors. An advocate may waive their fees for charitable organizations or cause, as in the case of African Child Foundation, where a seal maternal advocacy representing them without charge, possibly motivated by the desire to support a cause related to social responsibility, such as education of orphans. Remember this, the NGO deals with the orphan children. You get your give 3 points, 3 marks. So the B2, evaluate the evaluation of whether the conduct of firm of receiving maternal is professional acceptable. So the conduct of if it is conduct, you give 2 points, 2 marks. So pro bono work, the firm decision to present Africa AFC without charging fees aligns with professional ethics, standards, especially if they have voluntarily agreed to provide no legal service offense in a act, but for non-profit and which is allowed professional ethical guides. The firm has financial income case their professional obligation. They are willing to represent AFC without charging is acceptable. As long as they maintain integrity, transparency, and uphold the profession usually their conduct is consistent with their ethical practice. Yeah. So not and pro bono work. Action. Question 2, and I'm going to read it. You are newly admitted advocate. You are very proud to be learned friend. After an all-grueling legal study, a sleepless night, you feel that you deserve it. You vow that they will give you best to profession. I hope earn some big money while you are at it. However, you have some trepidation about the profession. As an avid newspaper reader, you cannot help but feel oppressive when you read of the advocate's skill in the line of duty. You observe with some relief that the Royal Society always speak out to condemn the murders. The general public seems unbothered, though. You have heard some talk in town that these quacks and misquanders deserve their untimely demise. You feel some are staring you because those who have died in line of duty have been legitimate practitioners. However, you constantly wonder if the society is acting the best of its ability. What duties do you owe to the profession? 6 marks, you give 6 points. Related to this question is duty of an advocate to quote client, public, and his or her professional colleagues. So that is how you interpret this question. Tested many parts times in the past, and in previous videos I've indicated the exact place the question is answered. Duty of competence of diligence. Point number 1, you must act in the utmost competence and diligent in your practice. This includes providing high quality legal services, ensuring you are up to date with law, and working diligently to present your clients while adhering to ethical standards. Point number 2, duty of integrity. As a lawyer, you're expected to uphold high standards of integrity. This means being honest, transparent, and acting in accordance with law and ethical principles. Your actions could reflect on value and truth and fairness. So, honesty and integrity answers are usually compulsory answers in every professional ethics. And also, I've said confidentiality. So, point number 3, duty of confidentiality, also a compulsory answer in every professional ethics paper. You must answer in. You must get a question that is asking you on duty of confidentiality. So you have a duty to maintain the confidentiality of current information. This is ensured in maintaining trust and integrity of the legal process. Discussing the confidential information without consent would harm your client's case and damage the reputation of the profession. Duty to court. You are duty to court to conduct yourself in respect and to present cases in honest and fair manner. Misleading the courts of obstructing justice undermines the integrity of the legal system. Remember Section 55 of the Advocates Act, which you have already talked about as your officer of the court. Yeah, so that is also a very common answer, compulsory answer in every question, professional ethics. Point number 5, duty to the legal profession. You must adhere to ethical guidelines and rules set by the society. and the legal profession. This includes respecting the legal community standards, cooperating with colleagues, and promoting rule of law. Point number 6, duty to the society. So, public lawyers have a broader responsibility to society they serve. They include contributing to justice, equality, and public good by ensuring the law is access to all, representing marginal groups, and upholding the principle of fairness, justice, of the society at large. Point number 2, how can LSK, question number 2b, how can LSK aid the legal profession to ensure advocates conduct themselves to the requisite manner? 4 marks, you give 4 points while explaining. This is an indirect question from the past papers again. So this question wanted you to discuss some of the objects under Section 4 of the Law Society of Kenya Act. So point number one, monitoring and enforcement of professional ethics. The LSK should ensure that all advocates adhere to strict conduct of professional ethics. This can establish and ensure disciplinary mechanism to deal with violation, ensuring and qualify an ethical practitioner are sanctioned and removed from the profession. CPD, Contention Professional Development, to ensure that advocates remain competent, well versed with the law. The LSK can organize regular training, seminars, and workshops to help keep practitioners updated and evolving legal standards, best practices, and ethical obligations. C, advocacy and public awareness. The LSK can take an active role in educating public about the importance of the professional legal services and those of advocacy in society. This will help counter negative perception of profession and foster respect for advocates. Providing legal protection and support. LSK should provide its members with legal protection, ensuring advocates are not harassed or attacked in line of duty. This may include offering legal defense in cases of threats and attacks and collaborating with security agencies to enhance the safety of practitioners. And also you can talk about a advocate benevolent fund that helps advocates in which have issues like sickness when they have been bereaved, and supporting the advocates of counseling, and supporting the advocates, children of advocates who are deceased. 4 points, give 4 marks. That is the answer. You go to question number 3. It has been the objective for 3A. It has been the objective for Advocate Mpenda Haki to be dependent in judgment and objective in course of offering legal services. Recently, a client, Fidelity Bank, entrusted him to file a court case against Craft International seeking damages for alleged breach of contract. 5 years ago, he represented Craft International in tax dispute case, citing the applicable issues that require consideration, circumstances in which there is a likelihood of conflict of interest that Advocate Mpenda should be aware. Then where Mpenda Haki can represent Fidelity Bank in the matter. So I've said that conflict of interest and confidentiality is a compulsory question in an exams. It must be asked. So this is what it was testing. So circumstance in which there is recovery of conflict of interest that Advocate Mpenda should be aware. 4 marks, you give 4 points. So representing of opposing parties, Advocate Mpenda Haki previously represented Craft International in tax disputes, and now is being asked to represent Fidelity Bank in a case against Craft International. This creates a conflict between his previous client, Craft International, and his current client, Fidelity Bank, are on opposing side. So point number 1, confidentiality information. As an attorney or an advocate, Mpenda Haki would have to access confidential information related to CRAP International during his previous representation. This knowledge may be relevant to the current case and could potentially be used against CRAP International, creating a conflict of interest. Point number 3, duty of loyalty. As an advocate, has a duty to maintain loyalty to client, and representing a new client against a previous client could undermine this duty, especially if prior representation could affect the new case. Then, point number 4, appearance of bias. Even if Mpenda Haki believes there is no actual conflict, there could still be a perception of bias or conflict of interest in the eyes of CRAP International public, which damages his professional reputation. So, whether Mpenda Haki can represent Fidelity Bank in the matter, remember I have said in the previous video that you read both the questions in a given, all the parts of the question, so that you don't answer this part for this part. So the first part was talking about the conflict of interest. So you should not answer whether Mpenda Haki can represent Fidelity Bank in the part 1, A1. So this is where the question is asked, whether Mpenda Haki can represent Fidelity Bank in the matter. So 3 marks, you give 3 points. Informed consent. Mpenda Haki could represent Fidelity Bank only if CRAP International consent to his representative of Fidelity Bank. The prior client, CRAP International, may waive his conflict if they are fully informed of the situation and give him explicit consent of the new representation. Point number 2, screening procedures. If there is no consent from CRAP International, Mpenda Haki may be able to present Fidelity Bank if he implements proper conflicts of interest screening procedures, such as have an attorney, an advocate handle the case, or implementing ethical walls, Chinese wall, to ensure confidentiality, information is properly used. Ethical guidelines and rules. According to SOPEC, an ethical guidelines and legal professional conduct, an advocate should avoid situations where their judgment could be compromised by conflict of interest. If conflict cannot be integrated through consent or screening, it would appropriate from Mpenda Haki not to represent Fidelity Bank in the case. So that is the answer. Part 3B of the question. Advocate Mpenda has been endorsing his firm's name and address on the document that he draws or prepare in relation to conveyancing. Evaluate whether the practice of advocate is premised on legal duty or essentially a matter of personal preferencing and branding. So he has been endorsing his firm name and address on conveyancing documents. So 3 marks, you give 3 points. So these are questions that has not been tested in the past. Since 2008. And this is the answer. So these are 3 points. 3 marks, you give 3 points. Each point you explain. In Kenya, practice of endorsing a law firm's name and address on documents is prepared in relation to conveyancing. So legal duty under the Advocates Act is point number 1. So the Advocates Act section its primary focus on issue process conduct. So you discuss section 34, 34A, 34B, and 35. So it's very, very important to understand these sections. I'm going to project. Remember, the question is asking you whether endorsing his fame or his address is a. So Section 34 talks about no unqualified person should not prepare certain documents or instruments. So if you are not qualified, you cannot prepare relating to conveyancing a property. So by putting firm and name address is showing that it is qualified. So section 34A, subject to section A, an advocate who the current practices shall not file any legal document in any registry and under the law which requires filing of such document or issue such document in other profession unless they are fixed on each document the stamp of seal issued by the society. So he must have a practicing certificate. So he's endorsing his firm name and address pursuant to section 34A. Validity of legal document, a practicing advocate who is not exempt. Legal document validity, it shows validity of legal documents under section 34B. I'm not going to read it. So 35.1, every advocate who does or prepare or cause to be done or prepare any document or instrument in section shall have the same endorsed cost be endorsed therefore in the name and address or name or address of the firm which is a partner or any person omitting to do so will be guilty of an offense. So he's doing that pursuant to 35.1, which requires him to do that. Yeah, so you discuss section 34, 35A, 35B, 35A. So that is a legal duty under the Advocates Act. So that is point number 1. Point number 2, conveyancing practice and client protection. In context of conveyancing, the inclusion of firm's name and address is not only professional norm, but also serves practical purposes. Client protection and transparency. Conveyancing is a complex legal process often involving significant sums of money and property transactions. The inclusion of advocate's name and firm and address on documents can be provided a point of contact for any future legal matters related to the transaction. This ensures transparency and helps protect the interests of clients by identifying the legal professions involved. The last point, branding and professional preference. With legal norms and regulation play a critical, the inclusion of firm's name and address could also be influenced by branding and personal preference. In a competitive legal environment, an advocate may use their firm's name as a means of branding to stand out in the market for their expertise and reputation. 3 points, 3 marks. Yeah. So question number 4, I read. Wakili George's practice is Merezi law firm. Merezi specializes solely on the family law. It is a top tier firm having reason to fame due to robust advertisement. In its advertisement, it routinely provides the names of clients and promises to win with tantalizing condition that if it does not, it will waive its fees. Underline that it's seldom fails to deliver, and because of this, business is booming. It's also contemplating on advertising on local stations to expand its reach. Underline that Mirenzi rarely purchases a policy of insurance because, as advertised, often wins cases because of it deems itself exempt from purchasing a policy of insurance. Underline that. Wakili Gorgeous persistently makes her client sign an agreement that relieves her from the responsibility of professional negligence. Underline that. She's a junior associate who is extremely adept to her work and never lost a case to date. Because of this, her client signed an agreement without question. Her client's boy, aging, ailing, and literate, has approached her with a complex brief that relates to land law. Underline that. Boy has referred to her one of village elders who has been a beneficiary of Merezi work. Boy figures that he has nothing to lose since Mercy will waive fees if it does not win the case. Wakili Gorgeous takes up Boy Bliss despite the fact that the last time she dealt with any Lando case was Anseri by exams 12 years ago. She is overwhelmed by the complexity of the case. She feels her cardiac caught in the headlights. She takes constantly seeking adjournment so much that the court has issued an order that the next hearing the matter will proceed with or without her, underlying that. Boy in the village is unaware of this, underlying that. The partners in Mirizi are concerned that Wakili Georges will lose Boy's case. They have a word with her and issue a stern warning for her to step up and pull up her socks. Elucidate the ethical issues arising from Mirizi law firm advertisement. So the question is asking you an advertisement. So 3 points, you give 3 marks. So question testing on candidate's knowledge, his or her knowledge on advertising and marketing rules, 2014. Discussed in year 2019 Q&A, page 142 to 146 in details. Repeated question, last question 5B March 2023 is a common question. You cannot go three rounds of past papers without finding it. So the answer is specific answer, naming of client in advertisement. Remember in the question we have been told the illiterate provides names of the client that is prohibited under Rule 5.2 of my marketing rules. Advertising of the possible outcome also is prohibited, Rule 5.2, and also advertisement in the lockup station prohibited under 7.2. So advertisement on the way violates advocate marketing as is a professional misconduct which can be subject to proceedings before a disciplinary tribunal. B, comment on the ethics of non-purchase of the policy of the insurance, 2 marks, give 2 points. So Rule 2 of the Professional Indemnity, 2003. So this question is repeated directly from the past Q&A and videos. So Rule 2 of the Advocate Professional Indemnity requires that an advocate to purchase a policy of insurance which is not less than 1 million. So the professional indemnity is for compensation for damage of claims due to professional negligence. That is Rule 3 of Professional Indemnity Regulations. So this is a violation. Rule 4 of Advocates Professional Indemnity, no practice certificate shall be issued to an advocate unless he has a, if he has a firm, if he has not purchased the professional indemnity. So this question brings why he was practicing, who issued him with a practice certificate where he had not purchased a professional indemnity. So it's a professional misconduct subject to proceedings in disciplinary tribunal. Question 4C, making reference to the Constitution, Royal Society of Code of Standards of Professional Practice and Ethics, Conduct, and other legal instruments, evaluates George Jurutes, Wakili Georges, evaluate Wakili Georges' duty to Boy. 5 marks, 5 points, you get 5 marks. So this question is testing on a candidate knowledge on duties on advocate to the client in context of the question, how the question have been asked, the facts of the question, repeated many times in the past. Constitutional duty, we start with that one. So access to justice. So the the advocate should ensure that boy has access to justice under Article 48, right to fair trial, Article 50, Article 51, 159, 2B, requires the judicial system to be accessible, impartial, and transparent. This means that worker judges as a lawyer must in the best interest of the client. You come to SOPEC 2017, Standard of Professional Ethics and Ethical Conduct for Lawyers 2017. You discuss competence and diligence. Advocates are required to have cases completely with due diligence. Wakili judges lack of recent experience with the land law and failure to seek appropriate assurance or refer to a more qualified attorney represent a breach of this duty. The rare scale code also mandates the advocates to avoid accepting cases beyond their competence, which is critical in the situation where complexity, like this case of land, duty to act in the best interest of client. Wakili judges must act in the best interest of the client, prioritize their needs by taking the case despite her lack of expertise in land. She is failing to protect boys' interests. Her repeated requests for adjournment, which arrived to court issuing an order to proceed with or without her, further jeopardizes boys' case and may result in miscarriage of justice. Professional negligence. Advocates must not act negligent in a way that must harm their client's case. Wakili judges' ongoing failure to handle the case effectively could be considered as professional negligence, especially if it leads to adverse outcome for boy. Confidentiality, you can discuss that. Point number 3, duty to ensure informed consent and protection of vulnerable clients. Boy being an illiterate and elderly client is particularly vulnerable in the situation. He may not fully understand the legal implication of the agreement signed by Nizi. Then there is an ethical duty on part of to ensure that he's fully compared the risks involved. Given boys' illiteracy and lack of awareness of the law, this raises concern about whether it's provide informed consent to the agreement that limits are responsibility for professional negligence. Duty to act for protect vulnerable clients. In this case, Wakarejeja should have taken additional steps to ensure that boy, due to his vulnerable condition, understood the terms of the agreement he signed. Point number 4, responsibility for professional negligence of Wakili, waiver of liability. Wakili judges practice on making clients sign agreement with liability professional negligence raises further concerns. Such waivers are generally not permissible. You discuss section 46 of the advocates where the lawyer conduct is negligent. Last point, duty of diligence and avoiding delay. Wakili judges' practice of seeking constant adjournment not only undermines the integrity of the case, but also violates the duty to act with diligence to clients and to avoid undue delay. SOPEC requires lawyers to act promptly and avoid unnecessary delays, which is critical to ensure client's case is not prejudiced. The court order to proceed with the house is a clear sign. So I'm given more than 5 points. You write them, you explain, you get 5 marks. Next question. Leonard Mukapi, the managing partner of Mukapi and Musil Law LLP. While asking for the vendor, 5A, sale of the land transaction invited the purchaser into his farm and proceeded to inform the purchaser that his client would obtain the land control board LSK consent for the purpose of the transfer of such. Should not have the reservation paving way of the purchase price. Consequently, the purchaser pays 60% of the purchase price. Nonetheless, the vendor refused to obtain the LSB consent and discontinued the communication with both Mukwapi and the purchaser. The purchaser subsequently sought to enforce the undertaking against Mukwapi, who argues that he is not liable and he was not in control of the activities of grant and the land control, and that of the purchaser misrepresented the alleged undertaking. Evaluate whether Mukapas is liable for alleged undertaking given on behalf of client and explain the reasons of the answer. So 5A, the question is testing on professional undertaking, a very common question in conversing. Last tested in question 6A, March 2023. So this is the answer. 5 marks, you give 5 points. Nature of professional undertaking. So in Kenya, professional undertaking are bound by professional ethics and legal obligations are given undertaking. Undertaking is a personal promise by an advocate to fulfill a specific obligation and is enforceable against advocate personally regardless of their client's action or inaction. So the advocate's liability arises from the fact they are expected to act with utmost care, good faith, ensure that the give is within the power to fulfill. Mkopa's actions by assuring the purchaser that the vendor would obtain the SCB consent. Mkwape effectively gave an undertaking that the consent would be obtained. This assurance is likely to have influenced the purchaser decision to pay 60% of the purchase price. Uh-huh. So you are evaluating and giving reasons. The Mkwape did not explicitly qualify his statement to indicate he was merely relying on client's intention and not personally guarantee the outcome. The purchaser could have reasonably interpreted the statement as binding. Remember, also a professional undertaking is usually written. So, yeah, vendor's refusal to obtain LCB consent. The vendor's refusal to obtain LCB consent as a subsequent act of comment does not absolve Mkwapa of the ability if his assurance constituted a professional undertaking. The enforceable undertaking is independent of the vendor's action. Mkwapa's defense. Mkwapa argument that he was not in control of vendor's action or SB may not hold if the undertaking was unconditional. So it's unconditional. Remember, the definition is an unconditional promise. The purchaser interpretation of assurance as an undertaking is critical, and the court could likely consider whether Mkwapa's words and conduct reasonably led to the purchaser to rely on the assurance. So what is the conclusion? Based on the above consideration, maker is likely to be liable for alleged undertaking. His or her assurance to the purchasers created a reasonable expectation about the SCB consent would be obtained, and the purchaser acted on his expectation by paying a significant portion of the purchase price. As an advocate, Mkwapa has a duty to ensure his statement do not mislead the purchaser or create an obligation he could not fulfill. Yeah. So Nini. The answer. It depended on your argument and reasoning. B. 5B. Shapi has been in practice for 10 years. She graduated at top of her class despite being the biggest scatterbrain in experience. She has a bit of chewing and popping gum roundly, especially when making submission in court. Her submissions are always brilliant, intellectual, and well researched, so judges tend to ignore her loud gum popping ways. She's supervising a people who is there to do his admission to the bar exams. Once in the virtual court appearance, in the absence of minded ways, she allowed her people to address the court. Things went away because of her people botched her submission and her card did not get the orders they were seeking. Despite Shapi's absent-mindedness, her saving grace is that she takes her duties to public very seriously. Discuss the ethical issues arising from the scenario. 5 marks, you give 5 points. So the question is testing an advocate's knowledge on court etiquette, tested in the many times in the past directly. So the ethical issue of professional demeanor. When Sharpie's gun pumping habit may not directly violate ethical rules, it would reflect poorly on her legal profession, undermining the decorum expected in court. Advocates are required to maintain professionalism, which includes appropriate behavior and appearance to uphold dignity of judiciary. Delegation of legal responsibilities. That is point number 2. Allowing her people to address the court during virtual appearance without proper supervision is significant ethical lapse. In fact, advocates should not allow people to address court. They have not right of audience. Mhm. Duty of competence and diligence. Sharpness, absent-mindedness with a personal trait must not infer her professional obligation, but the people to address court and prepare. She failed to exercise diligence and competence required of an advocate, potentially breaching her duty to client. Client interest. An advocate primarily supposed act in the best interest of his client. Sharp's action indirectly led to failure in securing the orders her client was seeking, which would result in complaints or claims of negligence. Last point, point number 5, public duty and professional ethics. Despite her absent-minded, Shapi takes her public duty seriously, which is commendable. However, her ethical responsibility requires she ensures clients receive competent representation at all times, regardless of her personal traits or challenges. The last question of the day, question 6A. Stephen Zawadi is a student at Kenya School of Law, undertaking the Advocates Training Program for purposes of admission to the Law of Advocates. While studying the Professional Ethics and Practice course, she comes across following statement in one of the reference books. A law firm ought to be solvent and be able to post profit in order to operate optimally, and to that extent, it is a business which must answer to business characteristics and needs. That is from Abres Wender, the Ideal Lawyer book. Zawadi is perturbed that the above assertion is potentially inconsistent with the affirmations articulated during the course lectures that legal profession is regulated professional undertaking. She is concerned that an absolute perception and practice of law as business may result in unethical conduct by advocates. Discuss the characteristics of practices of law as a regulated performance, in quotes, that advocates should adhere as a mechanism of preventing the degeneration of legal practice to ethical business and ethical business that Zawadi is concerned about. 5 marks, you give 5 points. So point number 1, adherence to code of ethics. So question is repeated indirectly from past papers like question 4B, March 20, 2023. Related to this question is question 1A, November 2017, which asks to what extent is practice of law a business? So point number 1, adherence to code of conduct and ethics. Legal practice governed by strict code of ethics, such as advocates. SOPEC, the rules emphasize integrity, honesty, and fairness, discouraging behaviors like overcharging, conflicting of interest, and misleading practices. Duty to court and the public interest. Advocates have a duty as officers of court, assuring and administration of justice. Duty to supersede the profit motive, as advocate must remain honest and impartial in presenting case or advising clients. They have an obligation to promote public confidence in the legal system by acting in the manner that opposes integrity and credibility. Professional oversight and accountability. That is point number 3. Legal practice is subject to regulation by professional bodies such as the Society of Kenya, which enforce standards and hold advocates accountable for misconduct. Mechanisms such as disciplinary tribunal and clients complainant system to ACC, it's answer they makes advocates answerable to action or breach of ethical professional standards. Confidentiality and client care. Advocates must maintain client confidentiality and provide competent, diligent representation. This duty ensures that clients' rights are protected and their trust is not exploited for personal gain or financial gain. Prohibition for unethical financial practices. The advocate are prohibited from engaging in practices such as bill assessing, fee sharing with unlicensed individuals or qualified people, against money laundering or charging exorbitant fees. Such rules help maintain balance between operating a law firm substantially as a business and adhering to ethical conduct. The last question of the day, 6B, Zawadi is required to make a class presentation as part of continuous assessment of the course under the theme of remuneration of advocates. A special focus is scale, postulated and advocates remuneration order. Her core argument is as adherence to the advocates remuneration order is economically justifiable as Chief Justice takes into account practical realities of practice of law by prescribing the scale. Discuss the factors that Chief Justice is obligated to consider which one should make reference to her presentation. 5 marks, you give 5 points. So this question has never been tested since 2008. And the question required a candidate or student to discuss Section 44 of the Advocates Act, which I'm now going to project. So this kind of question which requires you to discuss directly the Advocates Act or any other regulation. If you don't know, don't try to do the question. So on your screen is Advocates Act, Section 44. The Chief Justice may, and the last advocate remuneration of order was reviewed by Chief Justice Mutunga in 2014. So it's long time since it's been reviewed. The Council of may make recommendations to Chief Justice on matters related to remuneration of advocate. A Chief Justice, having considered the same, may order and prescribe and regulate in a such manner as this fit remuneration of advocate in respect of professional business, whether quotation and quotations. So an order made in this section for an quotation business may regard the mode of remuneration prescribed. It shall be according to the score of rates of commission percentage. So point number 1, varying not in different classes of business by gross sum. It is must vary in different classes of business by gross sum. Fixed sum for each document perused. So point number 1A, the position of party whom the advocate is concerned in the business, that is whether avoid or purchase a lesser or magoji. Point number 2, the place where the circumstance in which the business on that part was transacted. The amount of capital, money, or rent which the business related to. The skill, labor, and responsibility involved therein in parts of the advocate. That is like point number 4. The number and importance of document prepared by police without regard to the length. So A, B, C, D, those are the points. 44, 2A, B, C, and D. You discuss that. Those are the factors that the Chief Justice usually does put, and you get your 5 marks. Yes, and you are good to go. Thank you. Subscribe to the channel, view, take notes, be ready for your exams, and God bless you. So the next video is November 2024. Nice time.